All right. Lee, would you like to talk about the management of assets?
Sure, Patrick. Thank you. Management of assets. The objectives are to look out for the best interest of the surviving trust maker or other beneficiaries. And your plan of attack should be to seek professional guidance if appropriate and follow the guidelines established in the Revocable Living Trust. You don't have to carry on alone. You don't have to shoulder this burden alone. If it's a complicated estate and you need some help, by all means ask for it. When you are acting as the fiduciary, and that's a broad rubric term that covers trustees, agents under a durable power of attorney, covers executors under a will. When you're acting as a fiduciary, you are subject to something called the Prudent Investor Act. Prior to the Prudent Investor Act, which was really only about the last decade or so, people who were managing funds for other people were subject to something called the Prudent Person Rule. As long as you were acting in a way that was prudent as you would do for your own assets, that was the standard of care. As long as you were doing things reasonably prudently, that was the standard of care. Now they have upped the ante. In order to meet the standard of care required of a fiduciary, you have to invest and plan for those assets as a prudent investor would. And a prudent investor is one that takes into consideration a whole host of factors, including reasonable skill, care, and caution. Management decisions regarding the individual assets must be evaluated not in isolation, but in the context of the trust portfolio as a whole, as part of the overall investment strategy, having risk and return objectives reasonably suited to the trust. So you're going to have one set of objectives if you've got minor aged trust beneficiaries, another one if you've got older aged trust beneficiaries. Depends on each individual situation. So it's a very tough standard to meet. That's why, if you need help, get it. Dividing the assets. Identify the assets of the deceased trust maker. It's always the first step. Individual property, any shares of marital property. The property that's controlled by the trust provisions. Determine whether there's any priority of division of property to the family or marital trust. There's a lot of different formulas that are used to determine what assets go into what trusts. Determine what assets are covered by specific bequests, either dollar amounts or particular pieces of property. Prepare an allocation chart. Usually when we do this in the administration of a trust in our shop, what we do is we prepare an Excel spreadsheet. You start out with the assets, the value, how they were owned. Now you add another column that says how they're going to be allocated. Prepare an inventory list with the date of death values, retitled to the family trust or marital trust or other sub-trusts. So you're going to take these assets that are in what we call an administrative trust, which is the first step, pay out all the expenses, pay out all the taxes that are owed. Then you're going to divide those up further if needed. If you have a surviving spouse and the assets are under the estate tax exemption amount, then you may have only one sub-trust. If it's a second death and you've got assets going to 5 children, then you can have as many as 5 separate trust shares or even more. Distributions to children's or children's trust. Specific bequests can be made to children. Residuary bequests, that's everything else after specific bequests. And the trustee has the authority to make these distributions in cash or in kind. So if I'm acting as a trustee and I find out that the trust for the benefit of Johnny would like to have Grandma's car. Grandma's car is worth $10,000. So I give Grandma's car to Johnny and $10,000 worth of other assets to the other children. So it's up to the trustee to decide what to give to each beneficiary as their kind of bucket of assets. Promissory notes are frequently included in estates where people have made given a advance, so to speak, on their inheritance to a child by helping them buy a house. So if they gave Johnny $50,000 to buy a house, now they want to make sure that the other children are treated fairly, so they give the other children another $50,000 each to make up for what they gave Johnny and then divide everything else up in as many ways as there are children. If you have a family business or a farm, you've really got to proceed with care in making that kind of distribution. That should be subject to considerable planning before they even do the trust. What not to do. What you don't want to do is distribute assets to beneficiaries without consultation with an attorney or tax advisor. Don't transfer assets without proper tax planning and advice, especially IRAs and other tax-deferred investments. Don't liquidate or sell assets without proper tax planning. Liabilities. Patrick, you get all the fun topics today.
Yeah.